I think in the case of Disney, it brings up a very interesting issue in the trademark world, which is called famous marks. You have your regular trademarks, which cover your goods and services, and if somebody comes along and they use the same name as you, but they do something completely different, they can get a trademark on that. So for example, is everybody familiar with Sweetness 7 coffee?
It's a coffee shop, not far. Coffee shop not far from here.
Has anybody heard of
It's small,
Sweetness
it's
7?
independent.
No one's heard of it. Okay.
It's okay. It's still a good example.
Okay. It's a little coffee shop, right? Everybody loves it. They've got great coffee, great food, and it's called Sweetness 7. Now, if somebody on the other side of Buffalo wanted to come along and start making athletic wear called Sweetness 7, they'd probably be allowed to do it. And the reason is because the goods and services are so different. Sweetness 7 has coffee, and these people are making baseball bats. Nobody's going to think to themselves, oh, those baseball bats are from the coffee shop, right? That's what we have to worry about. But in the case of what are called famous marks, Nike, anything from Disney really, Ford, they get an extra level of protection. Ford Motor Company, they really only make cars. They haven't started making sneakers. So you would start to think maybe, oh, I can come along and make Ford sneakers. But you can't, because there's legislation that gives a little bit of extra protection to what are called famous marks. And this is an anti-dilution statute. So to prevent anybody from thinking that big Ford Motor Company is now making sneakers, we're just not going to let anybody use this mark for anything except we'll only let Ford Motor Company use it. Nike would be another example. Disney, as you can imagine, their trademark portfolio is huge. One interesting thing, though, that Disney did is that they've got all the money, they've got all the attorneys, but they lost a PR battle a year or two ago because they tried to trademark, and I'm not even going to attempt to say it. Does anybody speak Spanish in here? Anybody? Nobody speaks Spanish?
He does.
Oh, you do? Can you say Dia de Muertos? That one? Can you say it? Yeah, that. So it's like Day of the Dead, right? And they tried to get a trademark on that, and everybody was up in arms about it because they said, this is a holiday, you can't get a trademark. And Disney actually, I think they could have gotten a trademark, and I'll tell you why. Disney ended up backing down from it because the entire Hispanic community was up in arms over it. And they said, you can't trademark our holiday, what does this mean? We can't use our own name to describe our holiday. That's not actually what trademark law gives you rights over. But what happened is that the PR fallout was so bad that Disney just backed off from it. So let me give you an almost identical example. There is a trademark for the word Halloween for the Halloween series, the movies. Does this mean nobody can say Halloween? No, because all it means is that the people that own the trademark for Halloween, they're allowed to use the mark Halloween in connection with movies, and nobody else can. That's all it means. So you can still sell Halloween candy, Halloween costumes, have a Halloween party, all of that, and you're not infringing their trademark because you're not offering any goods or services, in the case of a party really, but to the extent that you are offering goods and services, you're not offering a movie. And that's why, in my opinion, Disney probably would have gotten the trademark if they hadn't backed down. So it was very interesting. That was kind of an example of where intellectual property meets pop culture, which is happening more and more these days, I think. So do I have any other questions?